for holding this important hearing on the American constitutional tradition that John Adams stood up for many centuries ago, and that is that a government of laws and not men. Simple concept. You don't even have to go to law school to know it. But I guess I'll start with you, Mr. Lacavara, who did go to law school. You served as Deputy Solicitor General and argued U.S. v. Nixon, along with Leon Jaworski. In your brief in that case, you wrote, "Under our Constitution, the people are sovereign, and the President, though Chief Executive and Chief of State, remain subject to the law." You emphasized the President, like all executive officials, as well as the humblest private citizens, is subject to the rule of law. 25 years after U.S. v. Nixon, commenting on your experience in the Minnesota Law Review, that was a good choice on your part.
Thank you for noting that, Senator.
Yes, you emphasized the President, like all executive officials as well, or you emphasized that your goal during Watergate was to enforce the obligation of every citizen, including one who just happened to be president, to comply with the law. Why do you believe the principle that no one person is above the law is a necessary cornerstone of our constitutional system of government?
Senator, I think it's implicit in the very separation of powers that Senator Kennedy was talking about. We separate powers, and the purpose for that, as the framers explained, was to ensure that government is limited. Senator Welch was talking about this as well. They chose liberty over efficiency, and I agree that it certainly would be more efficient, if that were the only goal, to allow the president to do whatever he wants to. But that isn't the system that the framers chose to embody in the Constitution, and I think they made it clear textually what they meant, and as Professor Naftali mentioned, the framers in their explanation for the Constitution said the president would be subject to various constraints, including the possibility of criminal prosecution.
Thank you. Very good. Professor McCord, independence from political interference is vital to the legitimacy and success of the Department of Justice. And I thought it would be interesting to ask you some questions about. That's why attorney generals of both parties have established clear policies to ensure that the White House does not tamper with criminal investigations and prosecutions, as Mr. McKeesey knows, or use the Department of Justice for illegal and untoward purposes. I've got concerns that the majority opinion in Trump v. U.S. jeopardizes the independence of the Justice Department. The court emphasized that, and this is the quote, "deciding which crimes to investigate and prosecute is within the president's," I'm paraphrasing that part, "conclusive and preclusive," those are their words, "constitutional authority, an area," this is their quote, "Congress cannot act on and courts cannot examine." You testified that by this logic, there is nothing stopping a president from directing the investigation of his political enemies, journalists, or activists, even when there's no basis for doing so. Can you elaborate on that?
Yes, and thank you, Senator Klobuchar. You're right that, I served in the Department of Justice for well over 20 years, and under every Attorney General, as well as every President and White House counsel, these no-context policies were enforced. They're not constitutionally required. It's not said in the Constitution, but it's something that respect for rule of law and has always dictated that both the White House and the Department of Justice sought to ensure that there was independence. I think that this opinion makes clear that there is nothing stopping an executive from directing his own executive branch, in particular here the Department of Justice. It's the very directions and conversations with Jeffrey Clark and others at the Department of Justice that the majority holds is absolutely immune. I do think that is dangerous going forward.
Could the court's decision mean that Congress and the courts are powerless to insulate any Justice Department official, from line attorneys to the Inspector General, from the direct partisan control of the White House?
I mean, this is the problem with conclusive and preclusive, and I would note that the case that comes from the Youngstown Steel case, Justice Robert Jackson made clear that when we are talking about a presidential claim to a power at once so conclusive and preclusive, it must be scrutinized with caution, for what is at stake is the equilibrium established by our constitutional system. And the majority opinion, which is of course the governing opinion, well more expansive than Justice Amy Coney Barrett's concurring opinion, which I think is much more well-reasoned and practically applicable, it raises these very issues that you have just posited.
Thank you very much. Thank you, Mr. Chair.
Senator Cruz.
Thank you, Mr. Chairman. The nub of the Democrats' argument today is that the concept of presidential immunity is somehow unprecedented, is somehow remarkable. That claim is utterly ahistorical and disconnected from the entire constitutional history of the Republic. General Mukasey